This is Steve Sanson and Ida. Ida, your last name?
Tajali.
Tajali. I am so sorry. I apologize. Jesus. It's been a rough day, folks. And we're here with Terry Coffing. He's a Clark County District Court Judge, Department 27 candidate. But before we get to Mr. Coffin, Ida, do you have any rants?
My only rant is that I hope that we bring back the civil bench bar this year in elections.
Oh, you almost scared me. I thought you were going to say, I hope we have a civil war.
No! Where's your head at?
I was like, oh boy, November 5th is coming up real quick. But, so that was it?
Yeah, that's it for now.
Okay. Mr. Coffin, tell us about yourself, sir.
Well, as you said, my name is Terry Coffing. I've been a resident of Clark County for more than 30 plus years. I was fortunate to raise two wonderful children here and spent the bulk of my legal career as a civil litigator, specializing in complex civil litigation, real estate, and related matters. But I also have significant criminal experience. As a young attorney, I've tried several felony cases to verdict. And so I'm the only person in this race that has both civil and criminal experience in what is currently a split department. So I'm very proud of the fact that I helped build a large law firm. I was managing partner for more than 20 plus years and have the business side of the law that really is, the business of law is business. And on the civil side of things. And I'm the only person in this race that can make that claim.
How long have you been practicing law now?
I was licensed in 1992 in Minnesota, 1993 in Las Vegas.
What's your bar number?
4949.
Wow.
Yeah.
That's pretty low. What were you on right now? 18,000 or something?
Yeah.
17,000?
Yeah, we're getting up there.
I used to joke that you can't trust a 5-digit bar number, but I can't say that anymore. So just edit that out.
Well, before I ask any more questions, Ida has a whole slew of questions she wanted to ask.
Okay. I thought you were going to go.
No. Ladies first.
Oh, okay. So one of the questions is, what inspired you to pursue a career in a legal field?
Well, as I probably sound like a broken record, when I was a kid, I only wanted to be two things. Number one was a professional hockey player. But by the time I was 16, I was pretty much out of the picture. Number two was a lawyer. And it's something that I always aspired to be and wanted to be. I come from a large family. I have 56 first cousins, and not a lot of them had post high school degrees. And so I wanted to stand out. Number one, I wanted to do well. Number two, and I wanted to make a difference. And so that's what has inspired me to be an attorney.
Nice. At what age was that, you think?
Oh, God. 10, 12.
Okay.
I really started to think about in those terms and how do I get there, getting from A to B. And I always thought that a legal career has a progression. You start as a student, you become a practitioner. And once you become adept at being a practitioner, then you move on to be a jurist or an educator. And right now, being a jurist is something that I'm focused on.
That's great. Let's see. My questions, sorry, got out of order. Let's see. In your legal career, can you think of any cases you dealt with that resonated with you and made an impact to you? And can you describe the case to us and why it had that impact?
Sure. The one that immediately leaps to mind is Thitchner versus Countrywide, which is still the seminal case on punitive damages in the state of Nevada. I represented this young military couple. They both spent 20 plus years serving their country in the Air Force. They had when they got out after their 20, they had two small children in a nice little condo in North Las Vegas. And almost immediately after, they joined the reserves. And unfortunately, the first Desert Storm came up, and Jerry Thitchner was recalled back to Tucson because he was an F-16 mechanic. He had very specialized skills. And so the family was separated for a period of time. And we originally, as often happens in the military, thought it was going to be 60 days, then it was 90 days, then it was 6 months, and then 6 months turned into a year. And ultimately, the family decided they didn't want to be apart. And so Katrina took their 2 kids, loaded up the car, and moved down to on-base housing down in Tucson so they could all be together. And she had some medical issues along the way that also spurred that decision. And they left behind their condo with all their things, paying their bills, the HOA, the power, and things like that, because they knew they would be coming back soon. Well, Countrywide, via Bank of America, was doing a foreclosure on Unit 110. The Thitchers were in Unit 100. And so they hired a real estate agent to do what's commonly called a trash out after they foreclosed. And she went to the wrong unit. And she immediately noticed, wait a second, there's food in the refrigerator, in the freezer, not in the refrigerator. There's clothes here. There's kids' toys. And the power's on, which is very unusual in a foreclosure. And she immediately went to the HOA and said, what's going on here? And found out their HOA dues were current. So it was very clear at that point in time that somebody had made a mistake. And somebody was going to ignore that mistake. And she proceeded to the agent on behalf of Countrywide, went down to a 7-Eleven and hired 3 or 4 day laborers, came and said, trash it out. And the neighbors testified the wedding dress, Jerry's dress greens or dress blues, the pictures of their grandparents who had been deceased and can never be replaced, the medal that George W. Bush pinned on his chest for his service in Kuwait was just summarily thrown in the trash. Anything of value they simply took, which is not uncommon in a trash out situation. So when the Thitchners come home and they open up the door of their house, everything's gone. There's things posted on the door. It's like, wait a second, we're current on our mortgage payments. We're current on the HOA. We're current on the power. And despite all these red flags, they just trashed it out. And so when I got the case and started prosecuting, doing the discovery, all these things were evident that it was clear that somebody lived in this house and they just didn't care. But the state of Nevada law at the time was, at best we could do is find trespass. They trespassed. And then they threw things out. And they argued with a straight face, mind you. And my opponent in that case later became a federal judge. Mm-hmm. Argued with a straight face. Well, the medals that were pinned on your chest, $45. You can go online and get another one. Your wedding dress, you probably could have got $100 for it online, right? And the callousness that was displayed in diminishing their lives was, to me, insulting. And ultimately, the jury found it insulting as well, with lots of heavy-duty motion practice. We had the biggest law firm in the state against us at the time, and we were able to prevail. We got a substantial punitive damage award that was immediately appealed, brought in the best appellate attorneys that they could find, because they didn't want that finding of punitive damages on their record. And that case stood out for me, number one. It had a lot of complexities, a lot of unique legal issues, but it really touched some people that we should revere and appreciate that did not deserve that kind of treatment. And the Supreme Court ultimately held that, look, you can make mistakes, and that may not necessarily be punitive, but you cannot ignore red flags waving in your face, telling you this is wrong, this is wrong, this is wrong, and escape your liability under our punitive damages statutes. So we got a substantial verdict at the trial court. It did get knocked down slightly at the Supreme Court, but we were able to recover enough for Jerry and Katrina and their 2 kids so that they can do their best to move forward in their lives comfortably. But they can never replace, like I said, the pictures of their grandparents. They're gone. You can never replace that. That there was a point in time during the trial where Jerry showed up every day in his dress uniform. And on a break, opposing counsel questioned, wait, Your Honor, that's not fair. He's showing up here trying to be, invoke sympathy because he's a military man. And I said, Judge, ask him why he's wearing that. Jerry, why are you wearing your dress blues? Because they threw away my suit.
He had nothing else to wear.
Exactly. He didn't have those resources where he could go out and, could he have bought a new suit maybe, but to have that level of callousness, and for the jury and the court, I remember distinctly in closing, it's very punitive damages cases are very rare. And so I was arguing maybe my second punitive damages closing, and they wouldn't say they're sorry. They never had the common decency to say to these people, we're sorry. And so I said to the jury, they won't say they're sorry. You need to make them sorry. And they did. And so that case had a great deal of impact on me personally and professionally because I developed a bond with the family, and it made Nevada law that is still current to this day.
Why did you decide to run for Department 27?
It was a very fortuitous bit of timing.
Because before you, sorry to cut you off.
No, that's right.
You'd have to run again in
2026.
And all those seats are up. Why now, and why this seat?
It was a very fortuitous bit of timing. For the last nearly 3 years, I've been the chief legal officer for a software company here in town. It's the billion-dollar company that's based in Las Vegas that you've never heard of. And they asked me to take a seat on the board of directors. And so once I took the seat on the board, I can't say a lot of things. The timing was just right. And so I talked to management and said, this is something I've always wanted to do. And we agreed that the timing was good. And so took a shot. I'm going to take my shot and give it my best.
Are you prepared to run again in 2 years?
If absolutely, I would be, and I would work hard to do that. I would hope that I would be able to do a good enough job, a job well enough on the bench where I wouldn't draw an opponent, because I do think that the election process for judges is flawed, very flawed.
Do you believe in the judicial selection?
Well, I believe in selection and retaining. I
So
believe
you
that
in the Missouri plan.
the modified Missouri plan.
Right.
Yes, I believe that the people should always have a say in who's on the bench, but the campaigning and the inherent conflicts that come up sometimes make for bad choices. So I'd like to see the people retain the ability to elect and have a say in who sits on the bench, but at the same time, I think competitive elections at the judicial level are somewhat flawed.
You have an extensive civil litigation background. Tell us about it. All of it.
I've had a very diverse background. As a young attorney, I never said no. So when
You get in trouble by doing that.
exactly. So what I mean in the context of you've got a criminal case, or a judge points me out and says, you're going to handle that criminal case. I did it. I did some family law stuff only because they were existing clients. But the vast majority of my work has been in complex civil litigation and real estate related matters.
So you're familiar with the business court?
Absolutely. I spent a lot of my time in business court. At one point in time, the 3 business courts were on the 3rd floor, just took the escalator. And I made a point every Monday, Tuesday, Wednesday, I was going to be there. Most of the times I had hearings, but I could always track down the attorneys that hadn't returned my phone call. And so a lot of business got done on the 3rd floor in business court. I believe in business court. We're trying to model against the Delaware Chancery Courts, which I've practiced in front of on 3 occasions. And it's a terrifying place to be because the judges are whip smart. They do not waste time. The counsel is the elite, and they make decisions right there. And so you may have Ford and GM fighting, but they're not going to go to trial in 4 years. they're going to trial in 4 months. And I'd like to see our business court get back to that model. I'd like to see the rest of the civil bench get close to that model where you get to trial within a year or maybe 18 months rather than 3 years or 4 years or even longer, unfortunately.
There are about 5 district court judges, correct?
Well, there were only supposed to be 3, but then they started splitting departments. So I think they do have 5 now.
Do you have a favorite?
That's a very good question. I would say I have respect for all of them, but my favorites are gone.
If all your favorites are gone. Who was your favorite then?
Betsy Gonzalez.
I was going to just say that. I was just going to guess that.
I thought he would have went with Tim Williams for some reason.
No, I liked him, and he was a good practitioner. I knew him as a civil practitioner, but I'm a little frustrated that he doesn't issue scheduling orders. He doesn't, you want to go to trial, you want to not go to trial, and to me, that's costing my clients and the public money.
So you're aware that you might have a dual calendar, correct?
Correct. Currently, it is a split calendar.
What's your background in criminal?
So, as I mentioned, in my firm, as a young attorney, I was the guy that was willing to go.
You didn't say no.
I didn't say no. In law school, I spent 2 years as a paid intern, not an extern, at the U.S. Attorney's Office. And I clerked for a district court judge in Department 10, Jack Lehman. And we had a civil, criminal, and domestic calendar back then because we only had 3 family hearing court masters. And so I got some experience there, and I do enjoy many aspects of criminal law. As I mentioned, I've done felony criminal trials, jury trials, battery with, and a robbery and burglary up in Reno in front of Judge Kasich. And so I have some experience. I did post-conviction release. I've had a lot of experience on appeals that I was appointed to, sometimes unwittingly, as I said. And so I do have that experience. And as a justice of the peace pro tem for 10 plus years, I presided over preliminary criminal matters. As a judge for a federally recognized Native American tribe, I presided over domestic, criminal, and civil matters. And so I've put people in jail. I've signed search warrants. I know what's happening on a criminal calendar.
Let me ask you something, because each judge has I don't know, it's a day or a week, I forget a month. I think it's a month when they sign search warrants and do all those things. And I know they do it in Justice of the Peace.
Almost daily.
Almost daily. What do you look for when a detective or Metro or a cop brings you a search warrant to sign? What do you look for? What stands out to say, okay, I need to sign the search warrant, or you know what, the search warrant is crap? What are you doing? What do you look for?
You look, number one, at the severity of the accused crime, right? And so you might look at a murder case or an accused murder a little bit differently than you'd look at and I don't want to trivialize any crime, a DV or something like that, where there's not a lot of physical harm. But what I look for is prima facie case. Have you given me enough facts where I can say with certainty that there's probable cause for that a crime was committed, and that you need, not want, you need a search warrant in order to establish guilt. And always being mindful of the fact that any type of search warrant is going to be intrusive upon someone else's rights, and those rights are co-equal. And so I would look at both those factors.
Have you had that opportunity to visit the Clark County Detention Center?
I've been in every prison or detention center in this state during my career, including the old, called the dungeon up in Carson City, when it was literally a dungeon. But I was in the Clark County Detention Center 3 times in the last 2 years.
What do you think of the facilities?
There's room for improvement. It can be very crowded, although
like a classroom, huh?
Yeah, they've alleviated some of the overcrowding. It can be too, I don't want to say impersonable, and I don't want to say inhumane, but there's aspects of it that do not respect some basic fundamental rights, I think. And so could that be improved? Yes, but I think you could say that on almost any facility, a detention facility. It's a very busy one. And I know when I had clients that were in prison and they were brought to CCDC for hearings, they always wanted to go back to prison. Get done with my hearing. I want to go back. Don't leave me here.
Well, it seems like Kevin McMahill, the current sheriff of Clark County, has been doing a good job cleaning up the police force. There's a lot of officers who've been picked up on, who've been arrested for various different crimes. If a law enforcement officer was in front of you, would you treat that person the same way you treat the everyday citizen?
As a party, or as
as the accused?
As the accused. Yeah, they would. I want to be fair and full disclosure that at my law firm, Metro was one of the biggest clients that we had. But I would think that everyone comes to court with a presumption of innocence, and they would get that presumption. But I don't think they'd get any more than that they're entitled to.
Okay.
So going back to when Steve was asking about your previous run for office, how do you compare that race with the current race, and what lessons were learned, if any, with that experience?
That's a good question. Number one, it was during COVID. And no matter what we think about COVID, that changed the dynamic of everything. And so that's obviously quite a bit different now. What I learned is that you have to take every opportunity you can to get in front of people and educate them. Prior to me ever running for office, I started a program, I self-funded, did all the work, called Edjudicate. Edjudicate, meaning educate people about the judiciary. And I set up a program where we would interview candidates for the district court bench and try to provide a mechanism, a website, some place they could go where they could learn about the people that are running. Because I think if 2020 proved anything, on many levels, qualifications didn't matter. It was, when you're handed a ballot and you've got 50 offices on there, some are unopposed, but some aren't. And at the end, and that's after you get president, senator, congressman, mayor, there's a fatigue that sets in. And if you don't take the time to educate yourself about those candidates, and if you're as a candidate, don't take the time to get that information out there, it's problematic.
Right. Talking about, some of the, when you were talking about business court and just in general, what things you'd like improvement on. In your opinion, what are the biggest challenges for this court in general currently? And what are your proposed solutions to address those challenges if you were elected?
The biggest challenges I see are efficiency and decisiveness, right? Courts, if you're not going to move things along and become inefficient, you're costing everyone money, including the taxpayers. And the reason why there's inefficiencies on that level is because there's a lack of decisiveness. A judge is there to make a decision, and I will make decisions. You may not like them and they may be wrong, but at least a decision that a bad decision is better than no decision, because there's 7 people up in Carson City that are going to be happy to hear about why I was wrong, but not having a decision, you're in limbo. And I take the case of a contractor I represented. He had a case and we had dispositive motions, important things in a case that was hotly contested. And he comes to me and he says, Terry, we've been under advisement for 2 months. I can't buy a backhoe. I can't hire those 3 guys that I want to run that backhoe. The guy that sold the backhoe or fixes the backhoe, he can't fix it. And it trickles down in a nefarious way. And so I would fix that by, number one, like I said, make decisions. Number two, I would issue tentative decisions. I've practiced in many other states, and not in many, I wouldn't say, some states. If you've got a hearing on Wednesday, and by Friday I've got all your pleadings, I've read them, and I've got a decision, I'm going to let you know. And that way, you don't have to send your attorney to waste 3 hours to argue something that I've already decided. And if I haven't decided fully, I would say, I've read your pleadings. I need you to address these two issues. Don't rehash everything that you just told me in the pleadings. These two issues. And that focuses counsel on what's important to me. And if it's important to me, it should be important to them. And it reduces the time that they have to send their attorney to sit into a crowded courtroom and wait for something that I may have already resolved or partially resolved. And that's number one. Number two, I'm going to show up on time. 9 o'clock means 9 o'clock. It doesn't mean 9:25. It doesn't mean 9:15. It means 9 o'clock. We had a great jurist here years ago, Stu Bell. He was on the bench 10 minutes early every day. And he didn't start early, but man, when it was 9:01, boom, you're going. We're up. First case, here we go. And I think that is a work ethic and an ethos that is sorely lacking on the bench today.
When you talk about decisions, what does the state law say that you have X amount of time to render a decision?
I don't believe that there is a state law other than the 5-year rule, which means that a case that once filed has to be brought to trial within 5 years, absent limited exceptions. In business court, we had a 1 year, but that was more of an aspirational goal. And if I can make it clear coming in that, say, guys, you come to me with a motion, you come to me with a continuance, you better have a good reason, and I might give you the first one, but the second one, you better have a really good reason. And don't tell me it's because I was too busy doing this and I didn't get to take that deposition. I don't want to hear that. And don't bring me a stipulation either, because you guys can agree, but that doesn't mean I agree. And so I think that can help spur efficiency. But the root of your question, I'm not sure, and maybe
is there a policy of the court, or is it in the judicial canons? You have X amount of time to render a decision.
There's a judicial canon that says you should act efficiently and expeditiously, but I don't think there are certain time frames. Maybe you'll tell me I'm wrong.
What happened if you made a bad decision and I don't have the money to appeal you?
Well, there's two steps. We still have a settlement process, right, at the Supreme Court level, where you can file a notice of appeal, a case appeal statement, pay that fee, which is relatively nominal.
I still got to pay my attorney.
Well, you still got to pay your attorney, but you're going to get a settlement conference. And at that settlement conference, hopefully we're going to have experienced people that are going to be able to say, maybe it was wrong, maybe it wasn't, and say to the other side, maybe you got lucky, and try to resolve the case at that level. But I'm keenly aware of having clients that say, they're wrong, but I can't afford to prove it. And so by making good decisions all along, even dispositive decisions, I would hope to minimize that.
How many times do you think that a judge would be overturned by either the appellate or the Supreme Court? All right, let me rephrase that, strike that. If a judge is overturned numerous times by the appellate or the Supreme Court, do you think that judge should stay on the bench?
I think that those statistics, which
because judges hate to be overruled or appealed or anything like that.
They hate it, but if
what would consider a bad judge? How many times? 12, 15, 30?
It depends on the complexity of the case. Like Judge Gonzalez, as I mentioned, she was overturned frequently. I mean, I won't say frequently, and that's not fair. Betsy, I'm sorry. But she handled some of the most unique and complex cases. But if you're consistently getting overturned on things that are well-established law, then number one, those statistics need to be made more public. They've always been kept, but they're hard to find. And they don't advertise, come here and see how this judge did. That's changing a little bit. But I would say if you're running at a 70% rate of affirm versus reversal, we need to pause.
The Supreme Court made a ruling, but it was regarding family courts, saying that the courtroom is of public concern.
Correct.
Do you believe that?
Absolutely.
Do you believe if anybody wants to bring a camera in your courtroom and go beyond what the jazz or whatever you guys got hooked up in there?
Jams. Yeah. Mm-hmm.
Would you allow them to set up a live feed and watch you while you?
I think it needs to be normalized.
What does that mean?
Normalized means there has to be a process, okay. Right? And we have to be careful that cameras in the courtroom are not set up in which they can be exploited to make someone look bad or someone look good. Mm-hmm. So I'm all for transparency, but there are instances, involving minors, involving children, and maybe some sensitive matters that do warrant that a level of privacy. But on the whole, I believe in transparency. I do not like, as a practitioner, every case seems to have a protective order. Every case seems to have a confidentiality order. When you look at it, it's like it becomes a game of gotcha. There's nothing confidential here. There's nothing that's inherently private here. This should be open, obvious, and public. If there's sensitive trade secrets, like I work for a company right now that we have some pretty sensitive trade secrets that our competitors would love to have. There has to be some accommodations, but in every case, no. I won't say run of the mill because every case is unique. You get two sophisticated parties fighting about a contract that they entered into and someone breached.
It's like the Colonel's secret recipe.
Exactly.
Okay, court observers. Mm-hmm. How about them?
I think the
court observers in your courtroom.
The courtroom should be open to the public. And so if someone wants to come in and watch proceedings, I don't have a problem with that. Just like a reporter should be able to do that as well.
What do you consider to be the most important qualities of an effective judge?
As I hit on, decisiveness, number one. The willingness to make a decision, even if it's a hard decision. Make the decision. That's number one. Okay? And so that's, I think, the most important quality because it cascades, as I said before, into efficiency and reducing costs for all litigants.
And going back to efficiency and making the decisions, I know that most judges expect the attorneys to submit the court order within 7 to 10 days from a hearing. So when do you think, or how, or when do you think a decision should be made so then that can be realistically accommodated?
Well, I think I can go back on my experience as a pro tem and doing small claims and some of those things. I was started every hearing with, I said, look, folks, I got one rule and one promise. The one rule is if I'm asking you a question, you need to answer my question before you tell me anything else. If I ask you what color the light was, don't tell me what time it was and what your kind of watch you have. So I say, because if it's important for me to ask, it's important for you to follow. And then the promise is, before I get out of this seat today, I may not make a ruling in front of you because it creates problems, right? It can create problems. But before I leave this seat, I'm going to have a ruling on your case. Now, that may not be entirely feasible at a district court level, but I would think within 7 days is an entirely reasonable time frame. I don't want to have things under advisement in perpetuity. I had a case involving a judge, you could probably guess who it might be, involving the constitutionality of a city or a county ordinance. And she set aside 2 hours for argument. It was a big issue. And I was fortunate enough to prevail on that. And she ruled from the bench, Mr. Coffing, I agree with you. And I said, I'm going to draft a decision. Your Honor, I'd be happy to work with counsel and draft an order. So, because I know it's important to the county that they want this matter decided. Waited 3 months, 6 months, numerous times. Judge, can I send you a proposed order? Can I do this? A year, 18 months.
No.
And that decision never came. And so what did the county do? I give them credit. They went and changed the ordinance. They went and changed the ordinance to an ordinance that they copied from a jurisdiction that did comply with the Constitution. And we never got that order because that judge's calendar was transferred to another judge, and then that judge unfortunately passed away.
Do judges take an oath of office?
They do.
And what type of language is in that oath of
They
office?
swear to uphold the Constitution, right? It's very similar to the oath that you take as an attorney.
Okay. And what's your favorite amendment?
Well, I would have to say the first. I developed a subspecialty in First Amendment law, and I represented many media outlets in this town, many people that I could point to that you would know that I can't name by name. And in all that time, in working for these media outlets, newspapers, TV stations, I found one case. Well, let me say two. I found one case that I said, you got to settle because you stepped over the line. And I found one case that I would take as a plaintiff. And I took that case, won the case, got punitive damages for my client because it was so egregious. But I believe the First Amendment is sacrosanct when it comes to that. And that's why cases involving the First Amendment are so difficult.
Have you done any mediation settlements?
Absolutely. I was fortunate enough to mediate a case with Alanis Morissette. I've mediated several other cases where I know both attorneys, and they came to me saying, hey, you know us both. We trust your judgment. We trust, your abilities. So I've done that. I can't say I've done that as a lot, but I've done it on many cases. I don't hold myself out as a mediator, but I've had thousands of settlement conferences, mediations, and that as an advocate.
How many trials have you done?
Trials. If you just say trials, big T.
Big T with jury.
Over 100. Jury trials, probably 30.
Over 30?
Yeah. And as I was at an event last night, and I said,
Which one?
this was at Kemfer Crowell, the Affinity Bars.
Oh.
I said,
You didn't invite us?
it wasn't my event. What am I going to do? I said, you know what? Don't believe a word I said. Don't believe a word I say about my experience. Google me. Get on Westlaw. Look for cases, my reported cases, the cases that I've tried. Go and look. I don't believe that my opponents could say that.
Have you ever write any literature for CLE classes and all that stuff?
Earlier in my career, I taught some CLEs in nursing home cases, which I had a kind of another dalliance into. I wouldn't dalliance, that's not the right word. I had kind of a subspecialty. And on some of the mechanics, very mechanical things in discovery, default judgments and things like that, but not a lot.
Let's talk a little bit about corruption. What happened if you had evidence that one of your colleagues, another judge, was violating state law or constitution law, or federal law, or having ex parte communications or anything like that? What would you do about it?
Well, as an attorney and as a judge, you have an obligation to report misconduct that you see in front of you, right? I'm a member. I've been for about 7 years on the board of governors.
You have an obligation, but would you
obligation.
Follow that obligation?
It would have to be. Yeah, I would. I have no reason not to. Because one judge acting badly reflects upon me, but it would need to be solid, right? I'm not going to do this based upon
willy-nilly.
Yeah, he said, she said. It's got to be solid. But yeah, I would have no hesitation in doing that.
Same with attorneys.
Absolutely. Absolutely. I believe as attorneys, we're inundated with these CLEs and these aspirational goals about civility in the courtroom. And I've taken a different tact. Civility doesn't come between opponents. It comes from the judge, right? If you see, I always use my meter. If I get a pleading and the rhetoric meter is like this, I'm going to call it out. Say, look, guys, this doesn't persuade me. It doesn't do your client any credit. If your client wants to beat their chest and say how wonderful they are, you need to do it in a legal matter. But we're going to decide the matter on the law, not on rhetoric, accusations, and unfounded personal attacks. So I believe civility comes from the judge, not between the parties. Although there is an obligation. And, Las Vegas is kind of unique. And I learned this by going to other states. I've tried cases in California, in Utah, Texas, Chicago.
You got one bar license, right?
Yeah, my Minnesota license is inactive,
Okay.
but I pro-hocked into other jurisdictions.
Gotcha.
We see the same attorneys over and over. And if I'm going to be nasty to you in this case, and then comes around a year later, we got another case, guess what? It comes around, goes around. So I've always taken the position that I've got to get along because that's in my client's best interest. I go to California and they know they're never going to see the same attorney again. And so it's
Not here.
it's scorched earth from day one, threats, yelling, and stuff like that. And it doesn't need to be that way. And it hasn't been here. I mean, it's changed from when I started, but it's not to the level where it is elsewhere. And I always keep that in the forefront of my mind. I always taught young attorneys, be careful, be careful what you say on the way up because you may get it on the way back, right?
That's true. Mr. Jolly.
So it goes to my question. How do you stay current with changes in the law and legal precedents?
Currently as in-house counsel and a board of director, I follow several websites like the Law 360. I keep up on changes in the law, especially in the area that I practice. And I watch what the civil court, the Supreme Court does. I look for, and being on the board of governors, I'm forced to keep current with developments and changes in the law.
And that's another thing I wanted to ask you. What boards have you been on and what boards are you currently on?
The board of governors for the State Bar of Nevada. I'm on a board of directors for Face Tech Inc.
Say that again.
Face Tech Inc. That's the software company that I work for. I've been on the board of, obviously, my law firm. I was president and chairman for many, many years. Those are the ones that come immediately to mind.
Okay.
I'm the manager of a half dozen LLCs, some of which are for former clients that I still maintain kind of relationships with. Some are personal. So,
Do you believe experience matters?
it's critical. It's critical.
How so?
I believe, especially in the civil arena, I believe that is it possible to spend 20 years in the DA's office and get thrust into a civil calendar and come out making good decisions? It's possible, but should the taxpayers have to pay for your on-the-job training and understanding that literally time is money in a civil courtroom? It's money. And as I used the example earlier of a contractor buying tobacco, and that trickles down. And I've been involved in many what we call bet the company cases, where the very existence of that company was dependent on the outcome of a case. And so I'm very much aware of that, having lived it. I'm also, having run a large law firm that had at one point in time,
How many employees?
well, at our peak, over 90, but that was before the internet, when I didn't need 8 runners, that kind of thing.
E-file.
Exactly. But I was acutely aware of the fact that, being successful fed families, that they depended on us. And as I've said many times, I know what it's like to be the guy that says, I'm not going to take a paycheck so you can have yours. I never say that to them. They never know that. But I know what that's like. I know what it's like to pay a power bill. and to find, a building. And so that business experience coupled with representing those same type of clients, I think is absolutely invaluable and something you cannot get in government practice.
You mentioned civility earlier. Being humble and empathy and compassion, is that anywhere in your wheelhouse?
Empathy, compassion, absolutely. Humility, number one, I'll say, find me a trial lawyer without an ego and I'll show you a transactional attorney. All right. But I think there's a level of there's a level of authority that needs to be asserted in a courtroom to make that a courtroom run. That doesn't mean arrogance. That doesn't mean yelling and screaming, being pompous. But the judge that I worked for back when we had bailiffs instead of marshals, he told his bailiff, and I learned a lot from this, that you're in charge of decorum in this courtroom. And it was not uncommon for him to walk up to counsel and say, "Counsel, mind your tone." And I don't have a problem saying that, because I do believe that as a judge, you deserve respect, but you have to earn it. And you don't earn it by yelling and screaming all the time, but you earn it by being fair and forceful in your courtroom.
End up like Mary Perry.
Who?
Mary Perry, family court judge.
I try to stay out of family court. I try to stay outside. That name didn't stick out to me.
Mr. Jolly.
Is there a type of law that you wouldn't dabble with, or like would that be family law? Like, what is a type of law that you'd be like,
well, I've done my share of family law. I did back, as I mentioned, I'm old enough, I'm dating myself. We had family court masters, 3 of them. I was there for prove-ups, and I, as I said before, I didn't like to say no. So if I've got this business client over here and he says, "Hey, my son needs a divorce," or he's got this. So I've done that. And in fact, one of my last cases was a pro bono case in family court that had a very complicated real estate issue regarding priority of liens. So I would not want to go there, but if you're telling me the places that I would not ever go, as someone who's been chief legal officer for a software company, it's intellectual property, because it's so specialized, so complex, but that will never come up in a district court. So there are areas where I'd feel less comfortable, like, for example, under NRS 92A, dissenters' rights. I've had cases like that, but of highly specialized, things where I'd want to make sure I had quality counsel in front of me and took my time and made sure the decisions were fair and balanced for those people.
We were talking about amendments earlier, and you said the first was your favorite.
Yep.
How do you feel about the second?
I own 14 guns.
Oh, very good.
Now, I had a carry permit back in the days when it was a may issue rather than shall issue as a law clerk. I do not carry actively anymore, but I do believe in the Second Amendment. I do believe that there may be some reasonable restrictions that are possible. I'm not sure I've seen them yet. But to me, owning a firearm was something that was in my family. And I wanted to make sure that if there were firearms in my house, that my children knew how to respect them. And they do. My son enjoyed shooting with me on some levels. Now he's 23. And my
How
daughter,
old was he?
First time he shot a gun with his dad, he was 10.
Okay.
And my daughter, I did take her shooting, so she knew how to respect a firearm, to know how to disarm or unload one if need be. But she just found it very distasteful and didn't want to do it. But she knows. She knows she's not going to pick up a gun that would, not that there would be one left out of my house. But yeah, I own guns.
Let's say you left, and you left your gun unsecured, and let's not go with you. Let's say someone, a parent, left their weapon unsecured, and their child took it, used it, and killed somebody. Whose responsibility? What does the state law say?
Well, Steve, you're getting a little specific. You know that. To me,
everybody blames me for that.
and specific fact patterns I'm prohibited from going. But here's what I can say: there's a level of culpability. Did I shut my safe and not lock it, and my child got into that and committed an intentional act? That's a set of facts. If I was a bad gun owner and left my gun in easy access of someone who had no right to have it, then there should be a level of responsibility there. Under state law, a parent is responsible for the intentional acts of their child up to, I think, the level's $10,000. So that's intentional.
That's a huge word.
Trust me, the parents of the two kids that broke into my house and damaged my house, they understood the difference of what intentional means. Mm-hmm. And so, so that's a very tough fact pattern that I need to have much more detail on.
Florida has a stand your ground law.
So does Texas, I believe.
What is the self-defense law in the state of Nevada?
My recollection, and without doing the research, my recollection is that you can use lethal force to defend the life of yourself, your loved ones, on a reasonable basis.
What happens if they're unarmed, but you are in fear of your life? Maybe they're much bigger than you or stronger than you, or maybe they might be on drugs, but they're unarmed and you use deadly force.
That gets back to a reasonable and a standard. But yeah, you come into my house and you're 6'8", 350. I don't care if you got a gun.
You come into my house, I don't care what size you are. Because I'm thinking you come to harm me.
Yeah. So, I believe in responsible owners of firearms. I believe in making sure your family is aware. My wife is aware of where every firearm is. There's only one that she has access to. And I'll be quite honest. It's a 12-gauge shotgun, and I said, all you have to do is pump it. That's all you have to do, because that sound alone will send people running.
But look, I want to talk about the 6'8", 300 pounds, because there's not many people that fit that description.
True.
But if somebody breaks into your house, you have a reasonable fear. You don't know what this person is. I mean, it's not supposed to be there in the first place.
Correct.
Self-defense law applies, right?
Oh, I would say so, but if
somebody breaks into your house and you don't know if they're armed or unarmed, they're just there.
I agree with you.
You're fearing for your life and your family's life, right?
If they break into my house and I flip on the lights and they turn and run, that's different than if they come at me.
Okay.
So
no shooting in the back.
No shooting in the back.
Okay.
Yeah.
No shooting in the back. I just want to make it clear, because I had David Rogers on the show years ago while he was DA, and he had a really, real good description of this. I'll tell you after the show.
David's a good guy.
Ida?
Can you describe a time when you had to make a difficult decision in a legal matter? How did you approach the decision-making process?
There were many, right? I've had to tell clients that no matter what you believe that you can prove and what the facts are, this is what I can get a judge to accept. And this is what it's going to cost you to get there. And you're wrong. I've had those tough conversations where they're adamant, their belief, and they're so, this is wrong. Understood, but I can't get you there. And as proud of I am as my courtroom accomplishments, I'm more proud with all the times I've kept my clients out of a courtroom. So yes, I've made those tough decisions, and I approach it, try to do it legally first, and then pragmatically. And I think that that's the appropriate way to look at things.
As an attorney, is there any laws that are on the books that you're saying, you know what, this should be changed?
Yes.
What are those?
Well, first of all, I'm glad we have a SLAPP statute in the state now. I'm not excited about the fact that
Be careful, because I used it a few times.
I know you have. I'm not excited that we've expanded it as California has. My last slap suit, I represented a famous UFC fighter, Wanderlei Silva. And, I thought we had a very good legal basis and to defend him and some very technical arguments. But then I've seen how it's evolved and been interpreted to go beyond matters of what's the threshold is public interest, right? And to me, that's
a big word too.
Two big words. I hate to see traditional defamation and law being accelerated unjustly and used inappropriately between private parties in a situation where the slap law applies.
Okay. All right. Mr. Jolly?
I have ran out of my questions, to be honest.
How do you feel, Mr. Coffin? How do you feel running for this seat? I mean, what motivates you? How do you get up in the morning?
That's a good question. Sometimes slowly, as I've now hit 60, and one of my opponents has made...
It's been around a few years.
Yeah. One of my opponents has made my age an issue, which I think is...
How old are you?
60.
Oh my God.
Well,
I wouldn't have guessed that, to be quite honest.
60 and you got
But if
78 running for president,
if I was
74 running for mayor, you're good.
If I was here on Monday, I could have said 59, so I'm going to blame you on that.
Oh,
Steve.
happy birthday.
Belated.
So, what motivates me is a desire, like I go back to, is that progression in my career. I want to, especially after now being on the business side of things, I want to take that final step. Maybe it's not final, near final step, and say, I did it. I did what I set out to do when I was that 12-year-old kid. Other than the Stanley Cup, which we talked about.
What motivated you to get into law?
I could see they make a difference. They help people. And I won't lie. There's a financial aspect to it that you have the ability to make a good living. And I'm not ever going to apologize for being successful.
Did you pay off your student loan yet?
Oh, I did that the second year I was out.
How'd you do that?
I was fortunate enough to work with my partner and friend, Al Marquis, on a...
You run a scratch of California.
And
Wow.
now we won a pretty significant case involving some engineers.
Oh, beautiful.
Yes.
Is there anything that we have not covered that you like to add
I would,
to this interview?
just briefly.
Sure.
In addition to wanting to be, I'm not gonna get a raise by being a judge. I'll tell you that right now. But aside from the finances, aside from that, I'm very proud of my pro bono service. I've handled some very tough pro bono cases. I'm not the guy, and I told people in the legal aid and things like that, I'm not the guy to bring in to represent a small child. That's not my skills. That's not what I'm familiar with. And I don't want to do him a disservice. I said, but if you get a tough one, a complicated one, give me a call. And if I can't take it on, I will help you through it. And the last two pro bono cases I had were very complicated. One ended up in federal court seeking temporary injunctions. And the other one was a very complicated case that I took over from somebody who's now on the bench. But I did so for free, involving, I think I may have mentioned, priority of liens. So that's something that I don't think my opponents in this race can talk about. One of them being a DA. I understand there's limitations to what they can do as a pro bono. But I think you got to give back. And there's people out there that deserve representation that simply can't afford it, or they can't afford the caliber of representation that they need.
I'm going to ask you a couple questions. These are hypotheticals. You're a sitting judge, and you found out that the prosecution was hiding evidence that would have exonerated someone, but yet the prosecution let that person go to prison. As a judge, what would you do?
Well, it depends on how it's brought to me. Was it brought to me concurrently, or was it after the fact?
Let's say it was after the fact.
After the fact, as you're aware, there's some very limited situations where you can consider new evidence. But I would consider that evidence. And if warranted, make the appropriate order. But as you understand, once a decision has been made and new facts, there's limited jurisdiction of the district court to come back and reconsider that until the Supremes kick in. So, but I would certainly hope that never happens on my watch, but I would consider those in the appropriate case.
What do you think should happen to the prosecutor who hid the evidence?
You're probably getting real fact dependent here.
I'm not trying to put you on the spot, Mr. Coffin.
You are.
I'm just talking hypothetical.
Yes,
because I want to have a clear understanding myself.
Well, I've been in situations in civil cases where it's been, wait a second, why didn't you produce that when I asked for it 9 months ago? I've been in that situation, and that's an infuriating situation to be in. And knowing full well that in all likelihood, unless I caught them, they never would have fessed up. So, but I would have to say that's very fact dependent. But if it's willing, knowingly done, I mean, the penalties are clear for that.
Okay. All right, very cool. Well, Mr. Coffin, you know that the Veterans in Politics, along with the Veterans Association Armed Forces Chamber PAC, endorsed you. We had that endorsement interview when you showed up with both of your opponents, and we chose you to be endorsed by all three groups.
Very proud of that. Thank you.
And we never had an opportunity to give you this plaque, and I wanted to present it to you.
Thank you very much. I'm honored. I appreciate it. Your endorsement and your willingness to educate people is laudable.
Mark is going to zoom in on you, and you have the final closing, and you can say whatever you want to say. And please give your website and let people know why they need to go to the voting booth and vote for Terry Coffing.
Well, number one, before you think about voting for Terry Coffing, please vote. Your opinion matters, and on all issues. And I urge people, even if you don't vote for me, I urge you to vote. Number one. Number two, educate yourself. So it's not a guessing game when you're in that ballot, when you're filling out that ballot. And number three, I hope that in some small way you can listen to my words today, and I hope I've earned your trust. And if not, don't believe a word I've said. Google me, go to Westlaw, and look at my abilities and judge for yourself. Thank you.
Mr. Coffin, thank you for appearing on the show. We really appreciate it. Good luck with you in your race.
Thank you.
Ida Tajali. Huh?
Thank you.
Yes.
Thank you for being my co-host. Really appreciate
Thanks
that.
for having me.
Absolutely.
Thanks for coming.
Folks, that's Terry Coffin. He's a candidate for Clark County District Court, Department number 27. We have endorsed him. Armed Forces Chamber PAC has endorsed him. Nevada Veterans Association has endorsed him. Veterans of Politics International has endorsed him. So he's endorsed by 3 veteran groups. We'd like for you to go out and vote for Mr. Coffin for Department number 27. Clark County is very huge. It goes all the way from Logandale, Mount Charleston, Searchlight, Good Springs, Primm, Moapa, Henderson, Boulder City, Las Vegas, North Las Vegas. When you get your ballot in the mail, vote for Terry Coffin. If you don't want to go and put it in the mail, make sure you go to your voting booth. Early voting starts October 19th. Election night is Tuesday, November 5th. Vote for Terry Coffin for Clark County District Court, Department 27. You will not regret it. This is Steve Sanson and Ida Tajali with Veterans in Politics. Until next time.